read the briefs. We're familiar with the record. Please keep that in mind as you make your arguments here this morning. As you approach the podium, please identify yourself and your clients for us. We are audio recording this argument and video recording it as well, and eventually the video of the oral argument will be posted on YouTube, so you can access it there. With that, appellant may proceed.
Good morning, Your Honors. Kenneth Schutt on behalf of the petitioner below and the appellant here, Dimitri Rosenman. The issue here today is relatively simple. The question is whether a receiver can be appointed when the only obligation is a child support obligation that has not been violated.
The receiver's been appointed since 2010.
That's true, Your Honor.
And why would we have jurisdiction to look at that from that period of time when an order was entered that was an appealable order but wasn't appealed?
Your Honor, the only thing we're seeking today is a reversal of the order refusing to terminate the receivership.
Okay.
We are not asking the court to enter any rulings with respect to the prior orders. So the question properly phrased would be, is it proper for the court to, or the trial court to continue the receivership in view of the fact that the obligations under the property settlement portion of the decree had been satisfied in full, and the only remaining obligation of the petitioner was a child support obligation, and that child support obligation was not in default. All of the payments under the child support order had always been paid timely. It was not in default at the time the motion to terminate the receivership was filed. So we're dealing with a situation where all we have is a child support order.
So in your view, counsel, the trial court should have terminated the receivership, and then at some point in time when your client was, if your client was then in default on the other obligations, the other party would have to then ask for the receivership to be imposed again?
That's correct, Your Honor. Unless there had been a violation of the child support order, there was no basis for the receivership. Under ARS 25508, it requires, in order to obtain a receivership in this context, an affidavit to be filed demonstrating that there has been some violation of the court order and that there are some arrearages for the child support in order to establish the right to the receivership.
Well, but it seems to go contrary to what you were just arguing, that there's no issue about the receivership. It's really only the issue of whether the trial court abused its discretion by denying your request to terminate the receivership.
Well, the termination of the receivership goes hand in hand with the continued receivership, the continued existence of the receivership.
But that's the, well, it appears that's the only way that the child support payments will be made at this point in time, or have been made in this point in time for the last 3+ years.
Child support payments were made prior to the appointment of the receiver in the first instance.
But that's history, and we don't have to worry about that. The only thing we have to worry about at this point in time seems to be whether the court erred by not terminating, by finding there were sufficient change of circumstances. And so what did the trial court miss?
Well, the trial court missed the fact that ARS 25508 doesn't provide for any other changed circumstances. It's very explicit. The legislature has laid out exactly what needs to be done in order to obtain a receiver in situations such as this. If you are attempting to enforce a child support order, you have to follow the mandate of 25508. And 25508 is very clear that you have to demonstrate that there has been some noncompliance with the child support order in order to obtain relief under that section. In addition, well, I'll reserve everything else at this point for rebuttal, unless you have any further questions.
I have one question for you. So the mechanics of paying the child support, your client's in prison, he has the business. Without the receiver, his manager would send the checks the payments? You can't do an assignment on the business, so how does she get paid her child support? I'm just curious.
The fact that he is in prison doesn't change the fact that whether he's in prison or out of prison, the company would have to pay him whatever he was entitled to receive under the operating agreement of the limited liability company.
So I think you mentioned those payments are being made to his prison account?
And I think at this point, they're being made directly by the receiver.
Right, but
Yeah. So, yes.
I guess what I'm asking you is this. I mean, as a trial judge, I would want to make sure that there was a mechanism to get the support payments made to wife every month. Husband's in prison. He's not running the business. And so apart from any desire not to make the payments, I might be concerned, how am I going to ensure that these payments get made regularly and on time to mother? And perhaps the best way to do that is to have a receiver appointed who's responsible to the court, and one of their primary responsibilities is to make sure those payments get made. But for that, whether the husband intends or is trying to avoid paying support payments, given the logistics, it might fall between the cracks. Tell me why that isn't a valid concern for a trial judge and a basis for appointing a receiver in and of itself.
Well, I think that you're anticipating problems that may never exist. First of all, there are a number of different ways that, whether you're in prison or not, you can assure that those payments are made. With respect to the particular situation we're dealing with here, the payments could be made directly to the prison account and then paid from the prison account to the mother, or they could be made into another account set up by the manager with specific authority granted to the manager to make sure that those payments are made in a timely manner. I think that the fact that there are a number of different ways you can do it permits the...
Let me ask you this. I apologize, counsel. I'm just trying to understand. So were some of those alternatives proposed by your client, or did that issue never come up?
The issue never came up, and I don't know that it needed to. I think the anticipation is that the payments are going to be made. The statute allows a receiver to be appointed if they're not made.
I mean, I agree with you. The anticipation is that. I don't want to go on too long about this, but as a trial judge, I would be concerned about how the payments are going to be made because the husband is in prison. He's not in control of the business. That's not anticipating a situation that might never arise. That is a fact. And so I'm just wondering, is an abuse of discretion for a trial judge under those circumstances to ensure that the payments are made, in addition to, I know, the property equalization payment, to have a receiver set up to make sure that she gets paid? And did your client suggest at any point in the record, Judge, you don't need to do that because I've got another way for you to make sure that this is set up? That's what I'm asking you.
I know at one point we discussed alternatives that could be provided to the judge in terms of offering security to make sure that the child support payments would be made. However, I think getting to your point, what we're dealing with here is a situation where you have a very somewhat lucrative business, and I don't know that the concern was so much that the payments wouldn't be made, because if the payments aren't made, then the father knows that he's going to be staring down the fact that a receivership will be appointed. So all he would have to do is miss one payment, one $1,600 payment, and suddenly a receiver is valid and can come in and run the business and do all of the things that you're suggesting. It's not like he's going to abscond with all the money and there's not going to be any ability to make payments in the future. As long as he's making those monthly payments, and you would know immediately if he didn't, then at that point the mother could come in, ask for a receiver to be appointed, as opposed to having it done in advance, in anticipation, without even giving him a chance to demonstrate that he will continue to make the payments.
Thank you, counsel.
Thank you.
Thank you, Your Honor. Stuart Halstead, appearing on behalf of the appellee respondent wife, Jana Rosamond. Doug McVeigh is sitting with me at the council table. To address basically what the court seemed to be focusing on with Mr. Schutt's argument, This is an extraordinary case. I hope I didn't overstate that in my brief, but this is a case where the husband planned to murder his wife.
We understand the facts.
Okay.
Okay, so the issue is, did the court err by not granting the motion to terminate? And you've heard the questions with respect to, were alternatives posed to give the court an opportunity to consider the issue?
Well, there were no alternatives proposed in this motion to terminate. That's not an issue. They simply asked the receivership terminated for the sole grounds that other payments to the wives had been made, even though the child support was still owing. And the facts of the case do go to whether the trial court was justified in appointing the receiver, whether there were facts supporting that.
That's not an issue on appeal.
Oh, okay.
Okay, you've heard his admission, that's not an issue on appeal.
Okay, if that's not an issue on appeal, that the husband would dissipate the assets, then I think that we're almost done here, because the court certainly has the power to enforce its orders. The remedies are cumulative. I cite that in my brief, that 25501D provides all duties of support as prescribed in this chapter may be enforced by all civil remedies as provided by law. 501E provides that the remedies by this chapter are cumulative and do not affect the availability of remedies under other law. The right to appoint a receiver and provisional remedies are clearly provided for in Rule 93H. And also,
what's your response to Mr. Schutt's argument that 25508 is a statute we should be focusing on to determine whether the trial court erred?
At 508, first, it's a alternative statute. It says that the wife or the creditor may seek these remedies. It's not an exclusive remedy. And it also lists, receivership as a potential remedy. It also lists provisional remedies. So if you had to be in default before you fell within that statute, why does it list provisional remedies? Those are prejudgment, remedies. 93.8 specifically goes to prejudgment types of remedies. So it's not an exclusive statute. We did file an affidavit with the petition for appointment of the receiver. The petition was verified to the extent that there's any affidavit requirement, which is suggested in the reply brief. That's been met. And he doesn't really, as an issue on appeal, he doesn't list that as an issue on appeal, that 508 is the exclusive remedy. He simply says it's a factual determination of whether the court should have terminated the receivership.
Counsel, let me ask you a question. So is what you or what your client contemplates that the receivership will just stay in place until the minor child turns 18? That'll be the mechanism for paying child support?
Correct. I suppose there's other circumstances that that could occur. I mean, I don't know what they might be, but I think that as things stand, that it would stay in place until the child turned 18.
So there's really no opportunity in your mind or potential for the receivership being terminated as long as there's ongoing support obligations by the husband?
Well, as I said, I didn't want to answer your question. I apologize for not answering your question, directly. But there may be circumstances down the road where it is appropriate to terminate the receivership. But I think those need to be addressed by the trial court on the facts that are, supported there. The concern is the child support obligation, and the child support obligation isn't only child support, is also paying for future medical expenses that aren't covered by insurance, is also paying for insurance. So it's more of an open-ended, obligation.
It seems that the receivership could, at least under the court's ruling, back in June of 2010, if the parties came to some agreement with respect to paying for those costs, they could agree, but in the absence of that, the court would have to determine the issue.
Correct. Correct. I don't think there's any automatic provision for it terminating until the child support obligations are fully paid. Now, the parties could agree, or, I mean, could there be circumstances? I would hate to say now that there's no circumstances whatsoever under what it could be terminated, but, you know, I think that the default is it's going to continue as long as these child support and health obligations remain. The other issue is if this is an issue of fact, which I think we've all agreed it is, it's in the discretion of the trial court. Mr. Schutt doesn't tell you what the standard for appeal is. I did, that it's discretionary in the trial court, and you review it on an abuse of discretion standard, considering all facts in our favor. And that would directly go to whether the assets are going to be dissipated. I think that's clearly, you know, a question of fact that, with respect, you should defer to the trial court on. The other issue is, since he is arguing facts here, it was his responsibility to provide transcripts, you know, of the various hearings, and failing to do so, everything should be considered in our favor. I think that's a appropriate ground for affirming the opinion. And just briefly on the issue of 508 as an exclusive remedy, that should have been raised in the original petition. I think, Judge Portland, you alluded to that is something that should have been raised 2.5 years ago on appeal, and under the Sato case, that's satisfied. The other arguments, I had a number of arguments on the 29655, the charging order issue, but as I understand Mr. Schutt's concession today, that is no longer an issue on appeal. Do you want to hear arguments on no,
I don't, anyway.
I don't think so, counsel.
Okay. It eliminates about half of my arguments, so now I have 12 minutes left where I was going to explain charging orders to you, but you're saved, I guess. I would ask about attorney's fees. We ask for it under both A and B of the statute. B is a mandatory section where if the petition or appeal, and the statute does apply to appeals as the cases I cited. B is mandatory if the appeal was not filed in good faith or without reasonable basis in law and fact. They appealed 6 different orders, 2 of which were stipulated. They've conceded what was, I thought, their basic issue in the brief today is down to an issue of fact, which is in the discretion of the trial court, which they didn't tell you. Under Section A, that's discretionary. Fees are awarded. Fees and expenses and costs are discretionary to be awarded, and that's based on the position of the parties. And the basic, reading the cases, they don't say this, but it seems like they focus more on the disparity of assets. I've cited the disparity of assets. There's a huge disparity of assets in this case, and we would request that the trial court, that the court affirm the trial court's ruling and award us our cost, expenses, and attorney's fees. And unless you have questions, I'm going to close very early.
Thank you, counsel.
Thank you.
Mr. Schutt.
Just a couple of quick items. First of all, Mr. Halstead indicated that when they filed their petition that they had submitted an affidavit in compliance with 25508. The affidavit didn't comply with the requirements of 25508. Secondly, in thinking once again about the alternative proposal that you had suggested, after the petition for termination of receivership was filed, a response was filed along with a motion to have a lien attached a lien in basically as security for the obligations of child support. That motion was filed by the counsel for the mother. And in looking at this, I think that that's probably the appropriate remedy as opposed to the receivership, given the fact that it would allay your concerns about whether or not, in fact, there was a potential that the payments would not be made, and yet it would give the husband the right to continue to run his business in the manner that he saw fit without interference from a receiver serving without bond. So I think as far as the receivership issue, the receivership should have been terminated. And the court denied the motion for the establishment of a lien as moot based upon her order with respect to the receivership. So as far as an alternative proposal, I think that would be the appropriate alternative under the statutes for dealing with a situation such as this, where there has been no violation of the court order, but you want to provide some security.
How would a lien that you're talking about provide for the timely transmission of these support and other payments?
Well, if there's a lien against property and the payments are not made timely, then the lien could be foreclosed to make sure that the payments are made in a timely manner.
And what would the lien exactly be on?
Whatever assets are owned by the father, those assets, I guess you're going to get into a circular argument with respect to 29-655 at some point, but theoretically, under the way that the statute should operate, whatever rights he has could be liened theoretically.
I'm just thinking back through this record. It seems that before the receiver was appointed, there was evidence suggesting that father, through an agent, was taking money out of the business and it would not be available to satisfy these obligations. So if the receiver is terminated, isn't that same situation going to arise again?
No, because the father would be subject to whatever liens are attached to whatever property the lien's attached to. So he wouldn't have the right to simply divest himself of whatever those assets are.
Well, I suppose this is all theoretical because these issues would need to be presented to the trial court for further consideration. I assume at some point you and your client, assuming we don't do something here, you and your client may still have that ability to ask the court again to impose a different construct.
Okay. Thank you, Your Honor.
Thank you, counsel. We'll appreciate the arguments presented here today. We will take the matter under advisement and issue a written ruling in due course. We're going to stand at recess to allow parties in the next case to come forward and get set up for the next argument.
I'm a former school teacher, and so I just do that with like, I'm going to have free in just a second. That was really a real kind of moment. I can't believe I just did that.
I do that to my kids all the time.
Oh, really? Good. Okay, good.
Sorry, would it be okay if we have a third chair at council table, or are we only permitted two?
I believe as long as you are all counsel, it's okay.
Yes.
We had an issue about 2 weeks ago with the client being
Oh,
here,
yeah.
and then